Okay, so when it comes to data, we've got two clear distinctions. We've got personal data and we have special data. And it's important to understand the difference between the two, because each has its own set of protocols, and each has its own set of ways in which we should approach data management. So personal data is any information relating to an identified or identifiable natural person, known as a data subject. And an identifiable person is someone who can be identified directly or indirectly, in particular by reference to an identifier, such as a name, an identification number, location data, online identifier, or one or more factors specific to their physical, physiological, genetic, mental, economic, cultural, or social identity of that person. Whereas special data, so special categories of personal data, have additional safeguards. And this includes personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union membership, and the processing of genetic data, biometric data, for the purpose of uniquely identifying a natural person, data concerning health, or data concerning a natural person's sex life or sexual orientation. So again, any healthcare information, anything specifically relating to that person's health needs will be classed as special data. But any other sort of identifiable information, such as their name, address, date of birth, etc., that would fall under personal data. So in practice, we deal with a mixture of the two, and each of those has to be handled in a different way. Now, it's important to think of why this special data category was introduced. So if you think back to the days in the US, for instance, of McCarthyism, and we had similar things going on in the UK, you know, not in the too distant past, where people's trade union memberships or affiliation with certain political parties were made public knowledge, and they were prevented from certain job opportunities and credit and such different things like that. So it's quite an important thing to bring in, that someone's political beliefs or someone's philosophical beliefs, etc., shouldn't be used and shared in a way that could prohibit them from accessing certain opportunities. So personal data, then we've got things like name, address, email address, date of birth, national insurance number. Special data will be things like racial origin, sexual orientation, health information, genetic and biometric data. So who actually looks after this data then, and who does what? So we have a data controller and we have a data processor. So the data controller is the person or organization that determines the purposes and means of processing personal data. So this is usually the practice owner or the company registered with the Information Commissioner. Whereas the data processor is the person or organization responsible for processing personal data on behalf of the controller, other than an employee of the controller. So for example, this could be an external provider that manages the controller's payroll. It could be a service provider who provides practice management software. It could be a lab contact lens supplier who's supplying lenses on behalf of the data controller. So the data controller is the practice, basically. The data processor is anyone who processes data on behalf of that practice, but not an employee of the controller. It's an important distinction to remember. So what are their key roles and responsibilities? So who is actually responsible for what? So the data controller then is usually the practice or business owner, or someone appointed by the practice or business owner, who has overall control and responsibility for how personal data is collected, processed, and stored in a practice or business. So the data controller is responsible for determining how and why personal data is processed, responsible and liable. Important to remember that they are liable for personal data, any breaches. They're responsible for reporting serious breaches, and they're responsible for ensuring that data protection processors, so data processors, people and organizations who handle data on the controller's behalf, comply with the law. So again, if they're using data processors to process any data, it's the data controller's responsibility to ensure that the data processor is also compliant. So data processors are all other persons who process personal data on behalf of the controller, other than a person who is an employee of the controller. So in an optical practice, this could include practice management software provider or payroll company, or labs, contact lens suppliers, etc., frame companies. It's also likely to include locums. And it's also worth remembering that data processors are also liable for breaches. So just to touch on the locum aspect of it, again, we should be ensuring that locums are data protection compliant. A lot of places that I've personally locum for will ensure that I've done some kind of GDPR training. A lot of the multiples will have some kind of online, quick GDPR workshop that you can do just to evidence to them that they've shown you the correct way to handle data. But most locums, anyone who's on the GOC register, should have a good understanding of data protection, as it is part of our 19 standards of behaviour when it comes to confidentiality. So patient data that's shared between the controller and the processor. So an optical practice, so that's the data controller, may send patient information to a supplier of spectacles or contact lenses, who would then be the data processor. So if the optical practice gives the supplier an ID number for the patient, rather than information that could enable the supplier to identify the patient, then the prescription is not personal data, and there will be no need for a GDPR compliant contract between the practice and the supplier. So that basically means that if we're ordering something through a contact lens company, for example, and we have an internal reference number, a purchase order number that we use to identify the transaction, then there's no personal data being shared. So there's no requirement for a GDPR compliant contract between the practice and the supplier. However, if we are giving the company personal data, such as the patient's name or the patient's address, so they can be shipped out to them, then that is personal data. And in that instance, a GDPR compliant contract will be needed. So most of the people that are going to be supplying us will be GDPR compliant. So it's not something we should particularly worry about in that aspect, but it's important to remember that if we are using third parties as data processors, it's best practice not to share personal information and just use a unique identifier, a purchase order number, an order reference number, so you can identify the information when it comes back into practice. So data processing officer. So optical practices are required to appoint a data protection officer, a DPO, if they provide GOS, or if they don't provide GOS but do process large amounts of special category personal data, such as healthcare data. So the DPO must have experience and expert knowledge of data protection law. They must report directly to the highest level of management and have independence to perform their tasks. So their other tasks and duties should not create a conflict of interest with their role as a DPO. So that can be a little bit confusing in a sense, because anyone who's working in practice that's actually processing data, anyone that has access to special data, you could argue that there could potentially be a conflict of interest there if they were to be in breach themselves or mishandle data themselves. So it's a little bit ambiguous in terms of who could actually do that role, but it's important that there is someone in practice who is in charge of that role and who takes responsibility for how data protection law is implemented. So the tasks of the DPO are to inform and advise the data controller and other staff about their obligations with regard to the GDPR and other data protection laws, to monitor compliance with data protection laws and policies, to raise awareness of issues and provide staff training, and to be the first point of contact with the ICO and for individuals whose personal data is processed. So it puts that responsibility on that DPO to make sure that all staff are up to date, all staff are fully trained on data protection, and that compliance is being adhered to in practice. And it should be the DPO that's basically the official point of contact for patients who request data or patients who want information that's stored on them. So there needs to be a clear and concise role with that. A lot of multiples will have this done centrally from head office, but if you are in an independent practice, then there does need to be someone who's got that responsibility. Okay, so within the realms of processing data, we need to identify a lawful basis for why we are actually processing that data. So once all of the personal data and the purposes for which it is intended to be used has been identified, we then need to assign at least one lawful basis for each category of personal data, and the purposes of the intended use must be identified before it can be processed. Now, each of these lawful bases should be documented and included in the privacy notice. And this is important because it can affect the rights of the people whose data you are processing. And if you decide to change the legal basis you use at a later date, you'll need to be able to justify that change. So again, this is where we go back into that privacy policy, that privacy notice, and gain valid consent for what we are actually going to be processing data for. Now, as we mentioned earlier, health data is a special category of data. So we need to identify both a lawful basis for general processing of the data and a condition for processing special category data. So again, there's a legal basis, a lawful basis for processing general data, but special category data also needs a separate category of condition to process as well. So as an optical business, our condition for special category processing will just usually be the provision of health and social care. So we've got a legitimate interest in providing that information and processing data because we are providing that person with healthcare. Now, when it comes to the special data, consent should not be used as the lawful basis for processing healthcare records or staff records. And this is because there are more appropriate and simpler lawful bases for processing these types of data. So someone comes to us for an eye examination, we don't need to consent to then process special data because they've come to us with the intention of having a healthcare investigation or a healthcare appointment. So we have more of a simple, legitimate interest for that, rather than just asking permission for us to perform that task. However, the processing of their personal data, we do need to, particularly for marketing terms and promotions, etc., then we do need consent for that. So yeah, so as I mentioned, you do not need to ask patients if you can process their data for healthcare reasons. If you are seeking consent for data processing, for instance, in order to send marketing material for patients, it is therefore important to note that this consent is separate from the patient consent you need to provide health services to a patient. So let's have a look at some examples of record keeping in practice. So we have a category of personal data in the data subject. We have a legal basis for processing personal data. We have who these personal data are shared with, the time limits for erasure, and any technical or organizational security measures which are required to ensure a level of appropriate security to appropriate risks. So we have GOS patient records, and we also have private patient records. And this includes retinal photography, referral letters, all that kind of stuff. So anything that forms part of that patient record would fall under this category. So the legal basis for processing that personal data is that the condition for processing special category data is the provision of healthcare. The lawful basis, the performance of a task carried out in the public interest and legitimate interest. So again, we have a legitimate interest to have that data processed because we are providing healthcare for that patient. So in terms of who this personal data is shared with, it's only going to be shared with registered healthcare professionals and those under their supervision. So GOC registered professionals, people who are working in practice would, even if they're not pre-regis or student DOs, etc., they would still be considered as working under the supervision of those GOC professionals. So those are the only people who this data should be shared with. Time limits for erasure. So the NHS specifies 7 years, or in the case of children under 18, until their 25th birthday. And it's accepted good practice in the profession that records should be kept for 10 years after the last contact with the patient. So in terms of security, so only registered healthcare staff should have access to the complete patient record. So there's no reason why a receptionist or an OA should have access to information pertaining to the specific healthcare of that patient. They shouldn't be able to see ophthalmoscopy and all that kind of stuff, all the stuff that's particularly relating to that patient's health, their medical records, their list of medications, etc., their other healthcare problems. all that kind of information should only be accessible by GOC registered staff. However, personal data, contact details, transaction records, dispense records, etc., then that can be accessed by anyone who's got a legitimate interest to access that. But there needs to be a clear distinction between who can access what within a patient record. So paper records must be kept securely. So they should be in a lockable filing cabinet. They shouldn't just be in a place where anyone can access them. They need to be kept securely and safely. And electronic data must be password protected. Employees should only be able to access the information essential for their role. And all employees should have passwords so there's an audit of any changes made. So it's really important that each individual protects their password. Passwords should not be shared. People shouldn't be logging in under other people's login details. And it's important that we treat that electronic data securely and safely. But it's important that there is an audit trail. So if there is any kind of breach, particularly from a fitness to practice perspective, if there were any kind of issues with how data has been handled or how records have been manipulated, then that audit trail is really important. So that password protection is essential. But there also needs to be a backup system. So any data that may be damaged can be restored. And it's also important that all antivirus software and other software is kept up to date to ensure that there's no issues in terms of data getting corrupted or hacked into. So customer records. So customer records, again, are different to healthcare records and different to patient records in the sense that they aren't generally relating to transactions and anything that a customer would buy, essentially. So the legal basis we have for processing this data is a legitimate interest. We are providing a product or a service for remuneration. So there's a legitimate interest for us to record direct debit payments or transaction details, etc. So this should only really be shared with the data subjects bank unless there's a third party who may potentially be processing direct debit information for us, for example. But other than that, there shouldn't be any sort of third party involved in the handling of this data. In terms of limits for erasure, time limits, these need to be kept for tax purposes and future claims and information. So again, it's not something that we should just destroy following on from the transaction. This information should be kept. Now, in terms of security, again, anything that's stored on paper should be kept securely. So receipts, any kind of paper transaction details, etc., needs to be kept securely. So whether that's kept under lock and key and stored somewhere, or whether it's scanned onto a patient record and then kept digitally, that's probably an easier option and then shredded. But if it's kept on paper, it must be kept securely. And again, with data, electronic data, it must be password protected. Employees should only have information essential to their role, and they must receive appropriate training for their role. So there are certain financial information that not every member of staff needs access to, but it needs to be relevant to their role. And again, the same rules in terms of audit trails, backup systems, and antivirus are applied here as well. Now, staff records, so this can include bank details, national insurance numbers, and other personal information. This may be relating to sickness, it may be relating to disciplinary and stuff like that. So there's training records, for example. So there's a lot of personal information, there's a lot of information kept about individuals in practice. So we need to have a legal basis for processing that data. So in this case, any special category data, the condition is processing is necessary for carrying out obligations as an employer. So the lawful basis is the performance of a contract with a data subject or to take steps to enter into a contract, legal obligations such as tax, and legitimate interests such as absence monitoring, disciplinary monitoring, etc. So this should only be shared with HR and payroll and senior management only. So we shouldn't have any member of staff accessing another member of staff's personal record, particularly if there is conversations relating to their health issues or disciplinary issues, etc. So again, it needs to be kept to those who it's relevant to. And again, this needs to be kept for purposes of tax, purposes of future claims and information. So potentially if there was some kind of tribunal or some kind of a legal issue later down the line, then we need to make sure that these records are kept for period of time that allows us to look back at that information if necessary. And in terms of security, same criteria applies in terms of how paper records are stored and how electronic data is password protected, etc. So all of those security measures apply to each and every type of data that we keep about patients, staff, or everyone. So how to be safe in practice? How can you be GDPR compliant in your practice, and what do you need to be aware of? So the first thing is, again, predominantly most practices are computer-based these days. So we need to make sure we've got good levels of computer safety. So we should protect information from shoulder surfers and eavesdroppers. So what is on your screen is potentially in view of people who could potentially access that data for nefarious purposes. So we need to make sure that people aren't looking over the screen. A lot of practices will have screen guards that limit the viewing angle of which you can see data. But it's important that we're not just leaving information up on screens, etc., where anyone can access it. We need to make sure that passwords are long and unique. So it shouldn't just be your initials or your child's name or your pet's name, etc. We need to have long passwords that are unique, that contain special characters, numbers, capitals, etc., to make them difficult to hack into. And we need to understand that there's an acceptable use of practice systems. So we shouldn't be accessing or getting patient information that's not relevant for what we have, it's not relevant to what we're actually processing it for. So there's been numerous fitness to practice cases where people have obtained patients' phone numbers, patients' email addresses to contact them on a personal basis. Things like that is not an acceptable use of a practice system. So again, that would be a clear breach of GDPR in that instance. So just be aware of who is around you and what may be visible to them. Be aware of what data is written and stored in your area of work. So this includes data not stored electronically. Have you got stuff written on notepads, post-it notes, etc., RX copies lying around, GOS forms, direct debit forms, all this kind of stuff. So anything that's written, anything that's got personal data on or special data, make sure it's not left lying around, and make sure that you haven't just got loads of stuff visible on your screen. If you walk away from your screen, make sure you lock the screen. Don't just leave information up while you go and help a patient choose frames. Make sure the screen is locked and personal information isn't on show, because anyone could then see it and have access to that information. Any personal data that is on paper, it must be shredded. Don't just throw it in the bin. Don't just screw it up in a ball and chuck it in the bin. It needs to be shredded and disposed of properly. Phone safety is also important. So again, be aware of who is around you and what is audible to them. Whenever you're discussing information, whoever's in earshot could potentially have access to that information and could be potentially making notes or remembering what's on, what they've overheard. So it's important that in this situation not to repeat sensitive data, especially payment information. I've seen it in practice where patients have phoned up to make a payment over the phone, and the person on the phone has repeated their long card number, their security code back to them over the phone. So this could clearly be overheard by someone else who could potentially, make a note of that information and access that patient's bank details. So it's really important that we're not repeating sensitive information. If we need to go away from the patient waiting area to confirm information with people or to have a private conversation, then that's always the best option. Also, make sure you know who you're talking to and confirm that they have permission to be given the data. So always get a confirmation that any personal data that you're giving out over the phone, you have specifically have permission from that person. So it could be the case that a partner or a husband or wife phones up on behalf of someone. If we don't have explicit consent for that data to be shared, then we shouldn't give that information out. But if someone rings up regarding their own data, then we need to go through at least a few pieces of information to confirm that they are who they say they are. And it shouldn't just be a case of, can you confirm this is your date of birth? They should be telling us the date of birth, the postcode, etc. of that person, rather than us just confirming or denying. So practice safety, be tidy. Don't leave personal or sensitive data lying around. Make sure that you keep data secure. Don't take written data outside the practice. So again, I've seen in practice where people have taken payment details over the phone, it's gone onto a post-it note, it's gone into a pocket to be processed later on the day because they're rushed off their feet. So again, really poor practice. It's quite easy for that information to fall out of the pocket, or they go out to the shops on their lunch or something like that. So any data must be kept securely in practice and never removed from the practice. But just being in that kind of tidy mode, making sure that things aren't lying around, making sure that you're not leaving stuff and information on your desk when you go off to other parts of the practice. It's really important that that information is kept safely and securely. So key points to remember then. Ensure that clear guidance and training is given to all staff who are involved in data handling and data processing. It's really important that everyone is on board in this, because ultimately the responsibility relies on the practice. And if you've got people in practice who haven't been GDPR trained, who aren't aware of data protection, how to handle data properly, then that's the responsibility of the practice, and any kind of breaches are the fault of the practice in that sense. So make sure that all staff are trained, make sure there's documentation of that training occurring, and then that's you covered in that aspect. So stay alert and protect privacy at all time. Treat sensitive data like it's your own. So just imagine that data is yours, treat it how you'd expect your data to be treated. So think of it as your personal information, and always treat it safely and securely. So consent is key to make sure we've got both a legal basis if we're processing some kind of information, special category data, but if we're doing any kind of marketing or providing any kind of information to a third party or another person, then make sure we have that consent, and make sure that consent is documented and stored on the record as well. And always remember the rights of the patient. So they have the right to access that information, they have the right to request it, to make sure it's adequate and up to date, and they have the right to restrict processing of that data as well. So always remember those key rights of that patient. Okay, so that's it for that then. So what we're going to do is there'll be some MCQs. So answer the MCQs, submit the online form, and then we'll get your points. So this will be broken down into 2 separate lectures, and there'll be 1 point available for each lecture. Okay, thank you very much.